All right, good morning. We're going to continue our consideration of House Bill 87. I think what would be most constructive is if we, today there's a fairly long list of people and or organizations. I think what might be most constructive is if today we focused on organizations, by that I mean business organizations, local government organizations, religious organizations, certainly issue advocacy organizations. And what I'd like to do is we'll sort of try to confine it to about 10 to 15 minutes each. I would ask the folks who are called forward to testify if they could limit any remarks that they have to about 5 minutes, because what that'll do is allow for a window of time for members to ask questions if there are any of that particular speaker. That way we can hear from folks who are interested in the issue from an organizational standpoint, and those various, again, the variety of organizations, and then but also keep the wheels on the track in terms of moving the process forward. I would anticipate the possibility, and given looking at the list and the amount of time to be allotted, which I hope is realistic, looking at the list, I think it's going to be likely that we'll go ahead and continue this for a final hearing on Friday morning at the same time, 9:30 until noon. We will be out of here at noon today, and if we go ahead and have a hearing on Friday, which I think appears likely, we'll go ahead and have 9:30 to noon then, and then that will conclude the public hearing portion of consideration of the legislation. Any questions from members about that? And we'll have, there are more members that are stuck in traffic right now, but I want to go ahead and start on time for purposes of having a good hearing, and they'll come in as they arrive. With that, and I've got this list of organizations, and I'll just go ahead and start with the Georgia Chamber of Commerce and David Rayner, who's Senior Vice President of Government Affairs. Mr. Rayner, welcome.
Thank you, Mr. Chairman.
Look forward to your testimony, and I'll admonish everybody as we go along that if you could confine remarks to 5 minutes, we can allow for questions, if any. That'll be helpful to us. Let me also ask, before I forget, if we could just put all cell phones on silent or vibrate. That would be most courteous to our speakers. Mr. Rayner.
Yes, Mr. Chairman. My name is David Rayner. I'm Senior Vice President of Government Affairs with the Georgia Chamber of Commerce, and certainly appreciate the opportunity to be here today. On behalf of the Georgia Chamber of Commerce and our statewide constituency of businesses of all size and across all industry, we certainly appreciate the ability to comment on this important issue. First, I wanted to publicly thank Representative Ramsey for his willingness to continually work with all stakeholders as this issue moves forward. The Chamber feels that reforming the immigration system is necessary as we see more of the state's resources consumed at the expense of tax-paying citizens as well as the business community. I would, however, caution the committee as you deliberate on this issue to please be mindful of the unintended consequences on business that could compromise our future economic vitality. I don't think anyone here today would argue that businesses who knowingly employ illegal labor should be penalized. I would stress the importance of compliance, however, to create a level playing field for businesses and citizens. Out of this process, I guess the number one thing that the Chamber would like to see is that employers will be provided with uniform standards and procedures for employee verification, and then indemnify those employers when they make good faith efforts to follow the law. The reason for indemnification, we believe, is mainly due to the fact that there are some inaccuracies that exist within pilot programs such as E-Verify. The state's business community should not be subjected to penalties and sanctions because an undocumented worker has gamed the system to receive employment. That's all I really have at this point. We certainly, again, appreciate the opportunity, and I'd be happy to entertain any questions from the committee.
What is your sense on the error rate on E-Verify? And when I say your sense, I mean I assume that's being backed up by some sort of documentation. And
right.
If you don't have it there, I understand. Just generally,
I don't have it, Mr. Chairman, in front of me today. I know that we've seen quotes from different reports that have shown anywhere from 50% all the way up to in excess of 80. I know that there's going to be folks here to testify today that would have more information along those lines.
Okay, so we'll look forward to hearing that from whoever may have it. If not today, then we'll get it from somewhere. Any questions from the committee? Mr. Vice Chairman.
You mentioned indemnification. Who would provide the indemnification?
Well, we would just hope that employers would be held harmless when they make good faith efforts to comply with if the committee's will is to move forward on E-Verify. We just don't want to see any criminal or civil sanctions brought against these employers who.
So what you're really saying is that they should be immune or exempt as long as they make a good faith attempt.
Right.
Okay.
And a good faith attempt.
Mr. Rayner, thank you.
Thank you.
We appreciate your time and attention this morning. Let me call on Todd Edwards, representing the Association of County Commissioners of Georgia. Mr. Edwards, I'll go ahead and admonish you like I have everybody else.
I should be fairly quick
But
with this, Mr. Chairman.
you're a seasoned professional, I understand. So.
Well, I don't know about that.
Thank you. I do.
Certainly would be testifying long enough before this committee. Again, I'm Todd Edwards. I'm with the Association County Commissioners of Georgia. As far as the question of compliance, which was asked earlier, currently we have, as you know, state, local governments, cities, school boards are currently required to use E-Verify and SAVE. As of February 1st, the 158 out of 159 counties were signed up for E-Verify. We have 87% complying with the SAVE requirements. We'll work with you, whatever is passed by the General Assembly. In fact, we have over the past few years through our webinars, workshops, training, and tools on our website to ensure that counties, A, knew that this was the law, and B, try to make them come into compliance with it. We're not all there yet. We're getting better, and as we move forward, whatever legislation is passed, we shall continue with those efforts. We, too, want to just express our appreciation to Representative Ramsey for working with us so far and addressing some of our concerns. Obviously, as was mentioned earlier by the Georgia Chamber, we would like to ensure that those counties that are working in good faith effort do not come over some of the penalties either in this proposed bill or in others. I mean, if there's a clerical error, if the information is not provided to them correctly, if there was something that, to lessen those or not subject them to the liability, we would certainly appreciate that. A couple of points in the bill, the substitute, several of them were addressed. I'll just go over them and down the list right quick. The private right of action still is a major concern to Georgia counties, to subjecting us to several lawsuits, whether or not they're based on fact, substantive evidence, those sort of things, as well as if they are, what it would do to our courts, to taxpayer resources at the local level. We will continue to work with Representative Ramsey in that regard, but that is the major concern of local governments. Another one is the standard which is applied for sanctions, finding that any agency has violated or failed to abide is the language that falls throughout. It goes back to if there could be language possibly inserted for knowingly, blatantly. I don't know if knowingly, I don't want to shield them, but again, if they're working in good faith, I'd like to have some consideration given to them not to be subjected to the standing, the penalties, etc. Another area is paragraph H in section 8. It gives law enforcement officers immunity under this, but it doesn't necessarily protect the law enforcement agency. If there were some language perhaps that can be considered in that regard, that would be appreciated. Paragraph 4 of section 9 mandates that counties include measures for entering into methods of understanding with the federal government. For the 287G program, it also requires us to put these in our comprehensive plans. These plans are not updated except every 5 or 10 years, so language that say when updated. As far as all counties complying with the 287G, I don't think that's required in the Act, but as we move in that direction, please keep in mind that the federal government at this point is very difficult. We have several on the waiting list, and whatever barricades or obstacles we encounter with the federal government, that's taken into consideration with compliance with anything that may make it through finally in this legislation. Another area is the verification requirements. The bill does not include the state in the list to make it as broad as possible, if indeed that is the intent of the author at this committee and the General Assembly. You might want to take into consideration expanding the reach to all corporations required to register with a state. Title 43, they do licensing for engineers, architects, etc. And there's also a great deal of special licenses that are issued by state agencies such as the Departments of Revenue, Insurance, and Agriculture, which are not included in this bill. Section 16, I just have 2 more, Mr. Chairman, I'll be done. Section 16, the AG is tasked with providing the list of acceptable, secure, and identifiable documents so that we know as local governments, because these may change over time. We do appreciate.
Can we get just a little bit of order as someone is actually sitting here testifying? Thank you.
I
certainly appreciate
that. Yes, sir, Mr. Chairman, I appreciate that. Section 16, the Attorney General has been tasked, and this was a language we'd originally recommended, with providing a list each year of what is a secure and verifiable document. Should this go into, and we appreciate that, but we would ask for a month or so leeway or time in advance, like before the law was to take effect, say it was July 1st, as is currently in this bill, if we could have our local governments, our clerks that will be administering this, that list 1 month in advance of the effective date. I think that would make it more efficient and may further ensure that we're better able to comply with the law. And last, section 16 again refers to part of what, when you're presenting a secure and verifiable document, it's for a license, permit, or official document. We're not quite sure what is an official document. If the bill could somehow provide some definition and make it clear. I mean, say, is this for a marriage license? Are they going to have to present this for a gun permit? Or what sort of open records request from a county? Is that an official document? But again, we will work with the General Assembly, with Georgia counties, to come into compliance. I'm here to present you recommendations for making sure that we facilitate that process, make it more efficient, and ultimately, make it easier for us to comply with what may pass.
On the private right of action, there's been some conversation about, and this is not my sense of it from the author, and as a co-sponsor myself, it's not meant to be punitive on local governments, but really to drive compliance more than anything else. It strikes me, just speaking personally, that an opportunity to cure, if there is a noncompliance, for X period of days prior to litigation kicking in some context, might be constructive for everyone. It drives compliance. It certainly will lessen any kind of litigation cost. Attorneys' fees are certainly on the table in terms for frivolous litigation. That's something the cities need to be fortified on, and the counties, excuse me. So, I mean, I assume that that's something that you would see as a constructive middle ground in terms of...
We would very much welcome that as a constructive improvement on this proposed legislation,
okay.
Sir.
Thank you. Mr. Franklin.
Thank you. I wanted to also address that private right of action. You were expressing concern that if a citizen were to bring an action because of the county's noncompliance, so that would clog up the courts and be an undue financial burden on the counties, if I understood that correctly. But don't you also believe that if the counties act unlawfully, that a citizen of the county should be able to remedy that, or to begin to address that in a lawful manner?
If a county is willfully non-compliant with the provisions of existing law or whatever may pass, then there should be remedy. And I think our major concern was whether or not there's any proof being brought forward. Is there any evidence? Is there to validate this so that we don't get
Isn't that
overburdened
what a trial is for? Is to look at evidence and let the trier of the facts determine whether that evidence is sufficient?
By that point, you're already engaged in significant county resources. If we could somehow, before those resources are engaged in this process with the trial, and I'm not an attorney, so forgive me. I do.
You're better off.
Yeah, this is always a rather tough one, but it's just an area of concern, the major one brought by counties. If there's some sort of evidence, we're not going to defend a county. I'm not up here to defend any county that's willfully non-complying with the Act. I would offer that removing their qualified local government status would also achieve those objectives. As far as the citizens, again, we're continuing to work with the author to address that. But I certainly understand the other point of view is to be able to file a complaint or an issue or bring it to the attention of when a government's not acting in good faith to comply with the letter of the law, sir.
Mr. Ramsey.
And I apologize for missing the beginning of your presentation, and I really don't have a question. Just want to say publicly, I appreciate the opportunity I've had to work with you and the counties from the time I introduced the bill to now, and I'm committed to continuing to work with you. We may end up having some philosophical we're going to have to agree to disagree, but I will continue to work with you to address clarifying technical concerns, and to the extent that you have your recommendations in writing, please provide them to me.
I will, and just as a recap of my initial remarks, we're expressing our sincere gratitude to you, Mr. Ramsey, for working with us in this process, and I will do so.
Ms. Abrams.
Thank you. Would it be effective, going to your concern about private rights of action, would it be appropriate or effective to include a provision that penalizes false accusations so that there's a heightened standard if someone's going to engage in a private right of action? Currently, I see there's a penalty for the county or city if it's found to be noncompliance, but there's no penalty for any person who tries to take advantage of this but submits false accusations or somehow tries to use this new private right of action to create harm or concern. Would you have a reaction to that type of proposal?
Any proposal in that regard, I think, would be appreciated by our members, whether or not it works both ways, with the loser paying the attorney's fees, court action, that sort of. But to protect us against mounting, they may not be frivolous, but without merit, I think we would welcome what I would consider enhancements in that regard.
Thank you.
Representative.
Thank you.
Mr. Edwards, thank you. We
Thank you,
appreciate
sir.
your time.
Members of the committee.
Let me call on Mark Woodall with the Association of General Contractors. If Mr. Woodall, there he is. Welcome. Good morning.
Thank you, Mr. Chairman. Mark Woodall with Associated General Contractors. We are a statewide organization comprised of 600 member firms throughout the state representing the commercial construction community. First of all, I want to thank you for the opportunity to be part of this discussion and specifically recognize the sponsor for his willingness to meet with us to address some of the concerns that we raised with the earlier drafts of the bill. We're going to continue to hopefully work with the sponsor. We commit to you that we understand this is a tough issue for everybody, and we want to be part of that discussion. For the record, I want to state what our official position is on immigration reform. For the record, our position is we support comprehensive federal reform. We support reform that strengthens our national security. We support reform that is fair and consistent and uniformly applied. And lastly, we hope our market turns around and we support reform that hopefully addresses our future workforce needs. Having said that, we understand the frustration that you as elected officials in the state of Georgia are going through. Everybody in the state and in our country has gone through for our federal government's inability or unwillingness to address this issue at a federal level. So as our state and other states go forward with addressing this topic at the state level, we would urge you to use caution, that we don't do something that puts us in a position of again, Mr. Raynard mentioned it, we're trying to comply with a complex federal law, and to the extent that we're addressing it at the state level or local level, not putting business in harm's way, but potentially violating a federal standard to comply with a state law. Mr. Chairman, just real briefly, want to get the committee up to speed on what our current status is as public works contractors in the state of Georgia. In 2006, with Senate Bill 529, we passed legislation in the state of Georgia that requires our public employers to participate in E-Verify, city, county, state agencies. We also required our public works contractors mandatory participation in federal E-Verify. And that requirement flows downstream for all contract parties, subcontractor, sub-sub. Last year we passed some legislation that actually was needed. Although the definition of subcontractor include every tier, there really wasn't a mechanism to assure public owner has the obligation to participate. They secure an affidavit from the prime regarding their participation in E-Verify. The prime has an obligation to secure an affidavit from their first tier subs, your plumber, your electrician, whatever, that they're participating. But if that first tier sub contracts downstream, there really wasn't a mechanism to verify that that party's participating. A situation occurred last year that brought that to light, and now the law is abundantly clear. Anyone in the chain of contracts has to comply and has to participate. And we currently are the only sector of our economy that is subject to penalty for willfully and intentionally violating or falsifying a public document. And we can support that. But we would echo Mr. Raynard's comments as well, that folks that are trying to comply with this tough, confusing law, that they be given the benefit of the doubt if they make an honest error in trying to comply, as opposed to a willful an intentional violation.
Let me just make sure it's clear. Good faith effort is not to be ignored, nor will it be. I just want to make sure that that's abundantly clear. But good faith effort has to pass the straight face test. I'm not saying that it won't in the example of contractors or anybody else, frankly. But no one should walk away from this morning thinking that good faith effort is just somehow invalid. It absolutely is.
Well, again, we appreciate the opportunity to work with the General Assembly on the prior activities on this. We want to continue to be at the table. But again, if we are going to go forward as a state, we believe there should be uniform application. My industry is not the only industry that is impacted by this debate, and it should be applicable to all industry and segment of our economy, and not just the commercial construction industry.
Mr. Ramsey.
Thank you, Mr. Chairman. And I'm sorry I missed Mr. Rayner's presentation as well, and I'll direct this question to him and you. I would just encourage you to the extent that you believe there is a provision in the bill that would expose a business acting in good faith to liability, I would ask you to point it out to me. Now, privately, you can send it to me in writing. I don't believe that exists in the bill, but I want to work with you if you believe there is an opportunity for a company acting in good faith to be exposed to liability. So that's just an open invitation. I know I've expressed that to you on numerous occasions, and will again to reiterate what I said to the Associated County Commissioners of Georgia. I look forward to working with you as we move this process forward.
You certainly have, and we sincerely appreciate it.
And just to make sure it's clear to audience members and members alike, it's an evolving document, as we all know, and that there may be concerns expressed by individuals that may be 2 or 3 drafts ago, for those of us that are working on the issue, and more importantly, listening to concerned constituencies on it. So, and we understand that, so that there may be issues that are being addressed that may not have quite come into the public conversation yet. So, I would ask folks, err on the side of caution. Let us know, but also know that that those comments aren't lost on us, since we are looking at an evolving draft. So, Mr. Setzler.
Thank you, Mr. Chairman. Again, Mr. Whittle, I appreciate you being here today. I appreciate what your industry does for the state, and I also appreciate your industry's commitment to comprehensive federal immigration reform. I think most folks in this room would recognize there does need to be comprehensive, meaningful reform. However, with our role as state policymakers, having the jurisdiction of state law, would you agree that even if the federal government were to act in a comprehensive way, we as a legislature do have a responsibility to make sure laws enforcing identity theft, fraud, misrepresentation of documents through contracts, those kinds of things, would you agree are within the purview of the state legislature?
Certainly.
And I think you'd also obviously agree that we've got to make sure that as there are advances in people's understanding of how to sidestep the law and get around the law and violate the long-standing laws of the state, we as a legislature have to make sure that we're closing loopholes and gaps. And I know you agree with that. I wanted to just hear you get your opinion on the fact that there are elements within the immigration debate that are specifically state issues, that the federal government alone can't handle this without some involvement by the legislature.
Representative Setzler, we did not oppose, and I think Mr. Edwards said the same thing, any party that is willfully and intentionally violating the law should be held accountable. But we don't want to have someone caught up in a gotcha for an honest error.
Thank you very much.
Mr. Franklin.
Thank you. You'd mentioned the desire for some comprehensive federal immigration reform. Although looking at the United States Constitution, I don't see where the states delegated any particular authority to the federal government over immigration. I see where we gave them the ability to establish uniform rule of naturalization. I don't see anything in the United States Constitution where the states authorize the federal government to have any policy on immigration, which would mean under the 10th Amendment that immigration is reserved to the states. So wouldn't you agree then that immigration is a state issue, not a federal issue?
Representative Franklin, I think you went over my pay grade to respond to some of that, but we are bound and governed by federal employment law that dictates what we can and cannot do to determine eligibility status for hiring an employee. It's federal law. We also have people that not only work in Cobb County or the state of Georgia, they work throughout the country. And to the extent that they can't be bound to comply with potentially 50 different state requirements or who knows how many county or municipal requirements. So the notion that the requirements that businesses go through to determine valid eligibility status, we do believe is the federal government's role. And we cannot be placed in a position of violating a federal employment law in order to comply with a state standard. And I think that's what I was trying to address in my comments.
And thank you for the statement. Just to make sure it's clear, the intent behind the legislation, of course, intent's not what matters. What matters is the words on paper, is that any law that does pass will be in compliance with federal law, because if we don't do that, we will have spent a whole lot of time and a whole lot of resource for naught. That is not our intention. That's not the way we're operating under this bill. That being said, getting good guidance from those both on the committee and not on the committee who have more of a background and good subject matter understanding of the issues that are presented in terms of that compliance helps us fashion a better bill, frankly. And we're all ears and all eyes when it comes to that. We would be foolish not to go ahead and welcome that input, and that includes your organization as well. So, thank you very much.
Thanks for the opportunity.
Let me call on Brian Tolar with the Georgia Agribusiness Council. Is he here? Mr. Tolar?
Mr. Chairman, I believe he's in another room watching.
With no doubt the audio not working in there. If I had to take a wild guess about that. Okay. Breaking laws down 400. Okay. Let me go ahead. Let me ask Ms. Bazemore if you might be able to identify him in the overflow room.
Yes.
If you could, or if we have a contact number for him, maybe. And we'll come back. Was there a representative from the Georgia Municipal Association that wanted to be heard? I know we heard from Mr. Edwards of ACCG earlier.
Yes, sir. I'd like to wait until the Friday hearing, if that's at all possible.
It'd be the committee's preference to go ahead and have organizations such as yours to go ahead and take your time today. That, don't get me wrong, that doesn't preclude your ability to go ahead and have another meeting, either privately or otherwise, or submit written materials. It's not a one-time shot, but for purposes of the hearing, that would help us expedite matters. And let me go ahead and admonish you as well, if you could confine your remarks to no more than 5 minutes in order to allow for questions.
Yes,
and Mr. Patel, if you could put the microphone closer to you. Right. Thank you.
I'd like to thank the committee here and Representative Ramsey for hearing our remarks. My name is Rushi Patel. I'm with the Georgia Municipal Association. And first I'd like to read our policy statement for immigration. And it's pretty simple. GMA will seek to ensure that any state laws placing mandates on cities related to immigration enforcement are practical, unambiguous, and reasonably administrable. GMA has been working with Representative Ramsey pretty consistently on this bill, and we plan on continuing to work with him. He's been very forthright in listening to our questions and comments, and sometimes we agree and sometimes we don't, but that's the process there. Our major issue with the bill is related to the litigation aspect, and we've worked with Representative Ramsey on that issue, and he's definitely listened to our ideas, and moving forward we hope to get something out in this bill that will work for both organizations, the state, and so on and so forth. Basically, when it comes to the litigation, we are greatly concerned that cities will be faced with a burden of litigation costs that they're not prepared to handle. As the language is currently written in the bill, anyone over the age of 21 can file a lawsuit, and that might lead to litigation that is unwarranted. Obviously, the intent of the bill is to allow individuals to file these lawsuits, and certainly there will be instances where there are lawsuits that are valid. However, our concern is this opens the door for a large amount of lawsuits that aren't valid. And so working with Representative Ramsey, I believe he understands that concern and has been working on this bill to alleviate those concerns. And moving forward, we continue to hope to do so. Further on in the bill, in Section 8, there are immunity provisions for police officers. As our associate at our colleague at the ACCG has pointed out, we'd like to see that extended to law enforcement agencies as well. It just helps law enforcement officers. I was previously a city solicitor in Brunswick. I know police officers tend to get the feeling that they're being targeted sometimes in these kind of cases, and we want to make sure that they don't have that fear and that they're able to perform their duty as public safety officers and protect the public. And on that note, back to the litigation part. Back to the litigation part, we are concerned that public officials, may be targeted with litigation. We feel that it should be the agency, the city, that is targeted if there is a litigation portion. We also believe that perhaps the attorney general or a district attorney would be a better source for potential litigation. That would reduce the potential for frivolous lawsuits. A DA or attorney general will be able to discover which ones were actually valid claims and move forward with those. And on that note, also, officials, if we're going after officials, it might not create an atmosphere where certain officials feel like they're able to perform their duty. Official could include a police officer. So,
Mr. Patel, let me interrupt you and just say, tell you the same thing that we told Mr. Edwards, and that is that the purpose of the bill, and the author can speak for himself, but certainly is compliance. It's not a punitive, it is ultimately not going to be a punitive measure against local governments or local officials or law enforcement officers individually in any way, shape, or form. It's about compliance. We don't want to have. We understand the recessionary effect just isn't felt here at the state level. We know it's at the local level as well, and probably more impactful at the local level now that we're talking about it. And we certainly don't want to offer any sort of chilling effect for individuals to step up and to serve. But there's one thing we do know about, it's that public service is a sacrifice. It's a willing, voluntary sacrifice. No one puts a gun to our head, but it is a sacrifice nonetheless. It's very challenging to be a local official. That is not lost on us. Many of us here in this body, we're local officials, so the walk has been walked by many of us around here. So I want to make sure it's clear to you, and of course Mr. Edwards and other officials, including my own city at home. I represent the city of Smyrna. The author represents Peachtree City, and so forth. That we understand the balance there. It is about compliance, not about a punitive nature, and my sense is that the committee substitute ultimately will reflect that. Ms. Abrams.
As a former solicitor, I'm going to raise the same question I raised for Mr. Edwards, which is, do you believe that it would be beneficial to include a penalty for false accusations or false or frivolous lawsuits where there's a threshold issue, so that you could discourage individuals from taking advantage of the private right of action? My concern would be that if the only consequence is court cost, that's sort of the solving the problem after you've already expended the resources. But if there is an earlier threshold issue where a person knows that if they institute a false action, they could face a misdemeanor or some penalty, that may serve as a caution to their behavior. Would you respond to that?
I would certainly believe that any sort of penalty that could be issued on a person that filed a frivolous lawsuit would be useful. The problem with court costs and attorney's fees is a court can order those. The person might not actually comply with paying those fees. So we would have an issue there, but the main issue is the litigation. And from the chairman and Representative Ramsey, they do seem to be wanting to work towards making sure that this is not a punitive bill. So,
thank you.
Yeah.
Ms. Ramsey.
To your point about potentially subjecting law enforcement officers in the private right of action, you would agree the way the bill is drafted now, it is narrowly limited to the 3 code sections, the requirement that public agencies enroll in and participate in the SAVE program, requirement of public agencies to collect E-Verify affidavits at the point of application for public works contracts, and the prohibition against sanctuary cities. None of those 3 code sections is going to be something that a law enforcement officer is in any way participating in compliance or enforcement of. Isn't that true?
Yes, sir. Yes, sir.
Okay. And I guess to my colleague Representative Abrams' point, isn't there in the law right now, and I am committed to continuing to work with you on the private right of action and addressing some concerns, but in the law right now there exists in the Civil Practice Act sanctions available that a judge can order for truly frivolous suits. Isn't that correct?
That's correct, and that's why that's not really a large concern right now.
Thank you.
For the GMA.
Mr. Sessler.
Appreciate you coming today. Would you agree if, in the broader effort to enforce the laws of the state, that if there were a city or a county that was willfully ignoring immigration law, or both the federal level or the mandates put out in 2006 in Senate Bill 529 to use the E-Verify program for employees and for contractors, I mean, do you agree that if cities and counties were either willfully ignoring it or just being generally unconcerned, sort of passive neglect, do you agree there would be a potential material effect on compliance with state law?
Willful ignorance of any law that's already been passed, and if this bill were to be passed, GMA does not condone that at all. Willful ignorance of the law is something that we should all go after. GMA has been working with our member cities, trying to get them, the ones that are not fully compliant with E-Verify or SAVE, to get them up to speed. We have employees going to the cities to show them to them. In a few weeks, I'm actually giving a presentation on how to walking people through the SAVE process, because as I'm sure everyone on this committee is aware, E-Verify and SAVE are very different in signing up. E-Verify is rather simple compared to SAVE. SAVE involves many steps, and sometimes, especially in smaller communities, folks are having a hard time understanding how to go from step to step. So GMA has been working with our member cities, and I agree that willful disobeying any of these laws, SAVE, E-Verify, or anything that may come forward from the state, is not something that GMA is willing to accept from our members.
Sure. Mr. Chairman?
Briefly, please.
I just wanted you to comment once again. Existing law does require that, again, public works contractors comply with certain provisions of the law. Would you agree that for contracts that are being executed for cities on city contracts, it is in fact the city's requirement to ensure enforcement of this provision?
Cities are required to get an affidavit from those contractors. Whether the contractors are falsifying those affidavits or the subcontractors or the sub-subs, that's something that we can't fully go after. They're testifying on the affidavit that they are E-Verify compliant.
Understand, but broadly under Georgia law, it is the responsibility of cities to ensure compliance with law and contracts which they're executing with their vendors.
Right. We're supposed to make sure that they sign that affidavit and that they say that they're E-Verify compliant.
So you would agree with the proposition that there is a role for cities in this process in ensuring compliance.
I completely agree with that.
Thank you, sir.
Thank you, Mr. Patel. We appreciate your coming down this morning. Thank you, sir. We have located Mr. Tolar with the Georgia Agribusiness Council. Thank you. Ms. Tolar, I'm going to tell you what I told the other witnesses. If you could confine any statement you have to 5 minutes, that'll go ahead and allow us
Absolutely.
to
Yeah,
go ahead and have a few questions before the time is expired.
Thank you, Mr. Chairman. I'm sorry I was located in the Senate.
No, not at
Portion
well.
of this building. It
You
takes
should
a
be
while to
sorry
get
about
here,
that.
so, yeah,
Actually,
that's right.
I was about to
Little
forgive you, but
breadcrumb.
not anymore. We appreciate your taking the time. We understand this is an important issue to the agricultural community,
Yes, sir.
and look forward to working with you on the issue.
Great. Thank you. Real quickly, my name is Brian Toller. I'm the president of the Georgia Agribusiness Council. We're a statewide trade association. We represent over 700 companies representing all parts of agriculture, everything from the farm to the table and the clothes on your back. So we're very proud to do that. We're certainly the state's largest industry, $68.8 billion, and we want to grow. And we want this legislation to do everything except hinder us from growing. So I will first say that I know it is the mission of the members of this body, and certainly the author of this legislation, Representative Ramsey, who, as I consider, always have and always will, to be a great friend and loves the state of Georgia just as we all do. This is a very delicate issue for agriculture because being the largest industry and representing economic impact in all 159 counties, we have a lot at stake in this. We are in the midst of trying to grow our industry in several ways, one of which, and we've heard the governor talk about it, and many of you have probably weighed in on it, the expansion of the port in Savannah. We want those large container ships to come to Georgia to carry agricultural products out, not bring agricultural products in. And the system that we have in place now with the technology that's in place, with the natural resources that are abundant to our great state, we are poised to grow this industry because commodity prices have finally reached a point where people are not talking about what do I have to plant to make a profit, but what can I plant so I can make the most profit. And when we look at that, we need to have a labor force to be able to harvest that product. And we obviously want to utilize and do utilize a legal workforce. The federal government puts in place the parameters for hiring a legal workforce. If we have employers now, whether they're agriculture or otherwise, that are not completing the I-9, then they're already in violation of federal law. We can't help them. This bill can't help them. I'm not going to try to help them. But when we look at the E-Verify portion, that really is the part of the bill that gives us the most challenge. And you've heard from others, and there's certainly different parts that give people challenges of their own. But for ours, it's the E-Verify requirement. And I apologize. I have not seen the latest draft to know where we are on the E-Verify part. So I'll wait to get details on that later. But if we require the E-Verify, then we are putting another layer of government on an already challenged workforce that's out there for agricultural production. And I'm talking getting your hands dirty workforce. Very difficult to find those workers no matter where you are. And over 2/3 of our counties, agriculture is either the number one or the number two industry in those counties. So we're not talking about small beans here. We're talking about real economic impact. So as we move forward, we need to see, and it is a federal issue. I know you've heard that time and time again. It is a federal issue. And Representative Franklin, I'll say that, and I heard your comment earlier about the Constitution, that we don't have any Georgia citizens. They're also U.S. citizens. And so we have to operate, because the U.S. is the one that provides us, the federal government provides us the visas that we need to get those workers in a guest worker program, to get those citizenship papers so that we can have those legal citizens here. And that's what we're trying to comply with. We're trying to comply with a federal system that also provides a federal outlet through visa programs through H-2A, which many of you may be familiar with, or H-2B. And I'll touch on them very quickly. H-2A is a very good program if you can afford it. The federal government says that the minimum wage for an H-2A worker is $9.11. And you provide transportation, and you provide housing, and you cover all the visa costs. It ends up costing you about $13.50 per employee per hour for those operations. If we could all drive Cadillacs, it'd be great. But everyone can't drive Cadillac. Some people can, others can't. So we don't need a Cadillac system, and that's what the H-2A program is, a Cadillac system. Now let's talk about H-2B. That's really where we get to our landscape workers, our urban agriculture, the environment we're in right now. That program is capped by the federal government, was capped in 1990 with 66,000 visas nationwide. In 2004, we reached the cap of that. We can't expand it. The state of Georgia can't expand that cap. All we can do is apply for it and hope like heck that we get the workers. Because if we don't, you're out of business. And if we're out of business, if we take a $68.8 billion industry and we take just a 10% hit, we're talking almost a $7 billion hit to Georgia's economy. And that's real. And when those farming operations and when those landscapers, when they go away, they don't come back, especially in rural Georgia. It's that much more difficult if you're trying to harvest a crop, if you're trying to milk a cow, if you're trying to care for chickens. It's a very diverse industry. It's a very complex industry. This problem is a very complex problem, and it requires a federal solution. But we understand immigration reform needs to happen, and we understand there are things the state of Georgia can do, and we recognize that this legislation carries a lot of different components in it that will serve the state of Georgia and will serve the state of Georgia well. But we take the biggest challenge of this legislation is with the E-Verify part and mandating that on private employers. And at that point, Mr. Chairman, I'll take any questions.
Let me ask you a question that warrants probably a 10 to 15 minute answer, but I'm going to ask you to do it in 30 seconds.
Okay.
Very reasonably, I think you agree.
Sir.
Where's the line? Where's the line between those folks in the agricultural community who this is perhaps not as big a deal, and with the folks where it is? In other words, where's that line of where compliance with H2A and E-Verify and everything that you've talked about? What's the comfort level? And I understand that's something of a subjective determination, and in our minds, we take an oath to support and defend and protect the law.
Yes, sir.
And we all take it seriously. I'm a little concerned about the fact that what I'm hearing is a message from you that says, well, we should enforce the law and protect the law and adhere to it, but only if we can afford it. And that's what I think I'm hearing. Tell me if I'm hearing something differently, and then tell me about who is in your mind, just from your industry, intra-industry, who can't afford it and who can't, and the size of that operation. But talk about the law first and how it is. I mean, that's the message that I just heard, and I want to make sure I didn't hear it wrong.
That's actually a 30-minute answer, so I'll do my best.
Yeah, I warned you.
With regard to who can and who can't take advantage of the H2A program, because it is an expensive program, the answer is it depends. It depends on what your commodity is. It depends on your locale for where your market is. And I know that's a lawyer-type answer. I think y'all say it depends a lot, too. But there is no simple answer, and it's because the industry is not simple. The solution is not simple. And it's not a matter of drawing a line to say, well, if we get above this point or we're below this point, then we're in or we're out. It's all about that individual operation and who they serve and where they provide those products in the market. As far as where do we go and how do we adapt to the system that's in place? Well, as I said, when the federal government put the I-9 system in place and they created the guest worker program, and the guest worker program is flawed, don't get me wrong. I mean, it's a nightmare because it is so hard for operations of all sizes to be able to utilize it. We need those outlets for those workers at the critical times, whether it's harvest or whether it's running a dairy operation, because dairy cows, they got to be milked every day. I mean, they don't wait for harvest season. I mean, harvest season's every day. And so the state of Georgia can certainly look to put different programs in place to put restrictions on private industry on how they go about hiring individuals. But they can't provide that outlet. They can't provide a guest worker program. They can't provide a source of individuals. Now, I understand we have a 10.2 unemployment rate here in the state of Georgia. But if you go to South Georgia, they're welcoming people every day. So it's not a matter if there's people unemployed. It's a matter of are they willing to be employed in this particular arena. And so we're trying to find workers that will go out and will commit to the jobs that need to be done and make a very fair wage, so that we can all enjoy the things that we enjoy, so that we can be here today having this discussion. And Mr. Chairman, I've tried to address again. It's a 30-minute answer, but really it depends, and it depends on a lot of variables. But our diversity is what creates those variables, and the opportunities for expanding markets globally also impacts those variables, because if we don't produce it, somebody else very well may, and we're already seeing Brazil and China and others that are taking advantage of those opportunities. But we want to provide our own resources here, not just in Georgia, but in this country. And we want to help do that. And we need workers to get that done.
Understand that it's a balance. It's a balance
Yes, sir.
between an enforcement responsibility that we feel that we have, paired with the understanding and appreciation of the fact that we don't want to be counterproductive as it relates to economic development and a major industry of our state. That's not lost on anyone.
I understand.
But it needs to be understood by all constituencies involved, whether it's in your business or from without,
Right.
that that doing nothing is not an option.
Right.
And relying to our detriment on a federal government that is not going to do anything anytime soon is not a realistic alternative. And what some of us hear, and I'm not saying that you're saying this, but in general, when we hear someone say it's a federal issue, let the federal government do it, that's really just a euphemism for do nothing. And that's not an option at this point.
Well, in all fairness, Mr. Chairman, and I apologize, I haven't articulated. I know we got to the point.
No, it's not taking issue with you. Please understand.
There are two things that I would like us to do.
Shades of that.
There are two things that I'd like us to do, and it doesn't require legislation to do either one of them.
Okay.
One of them might be a good piece of legislation, but one of them not at all. We talked about the expansion. You'll probably heard, you probably will hear people talking about how E-Verify, that companies can utilize it now. It's voluntary. And that we have companies every day that sign up in Georgia to utilize it. And that's great. And they didn't need a law to do that. I think we should do more to encourage businesses that want to get into E-Verify. They can do it themselves right now today. Sign up. Go online and knock it out. It takes just a few minutes, as everyone likes to say. I haven't done it, so I don't know. But I think we need to expand that opportunity and encourage businesses. And what can we do as a state of Georgia to encourage businesses to voluntarily do that? Now, the other part I would like to say, Mr. Chairman, is that over this last year, in 2010, we took on a 6-month process that y'all passed legislation last year to examine Georgia's tax code and to put together a great panel of great business leaders and economic experts, and went on a tour of the state of Georgia and met with business leaders, met with citizens, met with all different types of groups, and got input, and we put this stuff together, and we talked about how can we accomplish the goal of making Georgia a more competitive, more attractive, more economically viable state. We can do that with this program right here. We can go around the state and we can talk to folks in North Georgia. We can talk to folks in South Georgia and in Middle Georgia, and we can get their input, and we can talk about with them what would be the impact if we did this to a dairy producer, if we did this to a car dealer, if we did this to an auto manufacturer or construction. I mean, all the different private sectors that are out there. We can have that conversation, and we can come back and we can synthesize all that and see if we can't come up with a solution that works for everybody. So I would challenge this group to think about those particular areas to move forward.
We're going a little over on your portion, but I think it's necessary, Mr. Ramsey.
Thank you, Mr. Chairman, and my good and long-standing friend. We've been working together for a lot of years. I guess I'm trying to kind of get to the heart of your I guess your testimony, that the concern from your perspective is the requirement to enroll in E-Verify for employers that have 5 or more employees.
Well, really for any private.
That's the way it exists.
That's not doing business
that's
with
the
the
way.
state of Georgia.
That's the way it
worded?
exists
Okay.
under
Okay.
the bill.
I didn't know how it was still.
Is it the nature of the E-Verify program? Because in my experience, I've enrolled in E-Verify. Mm-hmm. It took a few minutes. It was an extremely easy process. The process of verifying an employee is a very quick process. Is it the nature of the E-Verify program you're concerned about imposing an onerous burden on employers, or is it just that it's going to limit, it's going to identify employees that are ineligible to work under federal law? So I'm just trying to get to the heart of what you're suggesting with respect to your concerns on E-Verify.
Right, and let me do my best to address that. It is not the issue with regard to E-Verify and how do you sign up. I know our folks in agriculture and certainly others all across this state are very capable of handling the registration process for E-Verify. I'm not worried about that. The part that I'm concerned about is where do we go? Where do we draw the line when as I stated earlier, when the state of Georgia is looking to impose a hurdle for private businesses without providing an outlet for those workers to come in. Just like the federal government put the I-9, they put H-2A and H-2B and other visa programs in place. They provided a system to bring people in when they didn't qualify under the current structure of that system. And the state of Georgia, as you and I have discussed, does not have that opportunity to provide that. And so that is the challenge, because when we talk about farming, we talk about agriculture, we talk about 383,000 jobs. And those are jobs that I know we all want to keep here. I want to keep them here. And E-Verify is not going to do anything to enhance that economic viability of that industry or any other industry.
But you're not really answering my question.
I'm trying.
If it's not E-Verify, the nature of the program, is it? It sounds to me you're saying it's just going to limit. It's going to limit, and it's going to provide a process by which employers are able to ascertain whether their employees are eligible to work under federal law. This is going to protect employers, for that matter, in terms of making sure that they're not violating any federal law that prohibits them from employing those that are ineligible to work under federal law. So it seems to me what you're suggesting is by requiring enrollment in E-Verify, the concern from your perspective is that it's going to put a mechanism in place where we're identifying employees that are ineligible to work under federal law. Is that?
Well, and I'm sorry if that's what you're hearing, because that's not what I'm saying. Because there is an assumption that E-Verify is the end-all, be-all for our immigration reform issues. And as you well know, and as your bill articulates in a lot of different areas, there's a lot of changes that are recommended for immigration reform in Georgia. And so this is one part of it. And what we're saying is, and as I've tried to demonstrate, is that where that program is available, and it is currently available, and that we should encourage businesses to get into it, not mandate businesses to get into it, that we should tour the state and meet with different types of businesses and different types of climates and different types of business atmosphere, so that we can determine what the impact would be, not pass a piece of legislation and sit back and say, wow, I didn't see that coming, because by then it's too late. Now, I know that's not your intent. But the challenge is, do we have the workers to do the jobs we need at the time we need them done? And so,
but so what you're suggesting is we should research the impact on the state of Georgia of putting in place a mechanism that will prohibit those that are ineligible to work under federal law from gaining employment in Georgia. You're suggesting that we as policymakers should go and engage in a process by which we study what the impact would be if we had a process in place that identifies those that are ineligible to work under federal law. I know we're kind of talking around this here, but that's what I hear you saying.
Well, and I guess it's more of at this point it's more of a philosophical issue too. The issue is, do we want the state of Georgia to mandate a control mechanism for hiring practices for private employers? It doesn't matter if it's agriculture or what. And I say no, we don't. And I say that if we pursue that without going through a process of vetting the impact to different industry sectors in different parts of the state, that we're setting ourselves up for unintended consequences. As a matter of fact, I can just about guarantee it.
Regardless of the fact that we know that if we don't set up a verification mechanism, that we know that there'll be aspects of that industry that are outside the law.
Well, again, we're assuming that E-Verify is the end-all, be-all to this whole problem, and we know it's not a perfect system either. But the challenge we have is maintaining an economic base of workers, regardless of whether we have E-Verify mandated or not. We already have an I-9 process. It's not like we're not just throwing the borders open and say, y'all come because we're not looking. That's not what we're saying at all. We're trying to follow the federal process and utilize the federal program to be able to bring those workers in when we cannot get seasonal workers under the current hiring practice for getting locals in the door. So that's all I'm saying, Mr. Chairman.
I want to apologize to members. I'm going to have to excuse Mr. Tolar, but we're going to reserve the right to ask you to come back if
Sure.
necessary, because we do have to go ahead and move on to other people who want to be heard. Like I said, this is not a one-time process. We'll go ahead and perhaps have you back.
And Mr. Chairman, if I could, this is not an advertisement, but the data that I use comes from the University of Georgia in this little ag snapshots. I'll be happy to provide. It's all ag economic data. It's provided by University of Georgia, so it's not my it's not my data. It's theirs.
We understand. We understand your time. We understand the difficulty of the position that you're in.
Yes, sir.
We can only hope that you appreciate the balance that we have to strike as well.
No, absolutely. Yeah.
Mr. Tolar is
Totally
a
respect
fixture in this Capitol, and so members are free to
Happy to
get
help
with him.
answer.
But we, again, will, as we go on, we'll be talking about having other meetings to perhaps
Okay,
ferret out individual issues with a
So
little
you
more
don't need to
depth.
stick close right now, just for later on during the session?
I'll-
I'll
well-
be in the building.
Right, I know
Okay.
that. All right, thank you. Thank you. Yeah.
If I could just ask Mr. Tolar if he would please get with me offline, I need some statistics from him.
Yes, sir.
And in the interest of time.
Sure. Thank you, Mr. Atwood. Let me also ask, individually, if anyone has written materials they want to use as a supplement to their testimony today or in the past or in the future, to please get them to Ms. Bazemore, and we'll go ahead and distribute that as as a supplement to any comments that people have.
Sure.
Okay.
Thank you.
Thank you. Yeah.
This is the second time I've had my button pushed and was not allowed to ask a question. And while I do respect the right of the chairman and of the sponsors of the legislation to inquire of those testifying before this committee, I think it's only appropriate that at least one question from an opposing view be allowed to be asked of each of the members who are coming forth to testify.
You were recognized in the previous round. We did have a couple of questions that I thought I might go ahead and ask a question or two for a change of Mr. Tolar. There is no preclusion on your communicating with Mr. Tolar, whether it's here or outside of it. What I have to do is strike a balance, Ms. Abrams, between having a full, fair hearing and also making sure that we have people heard from. So.
With all due respect, this is not simply a conversation with Mr. Tolar. It's a conversation with the audience members who are both present for this public testimony and with others. And I'm not asking that we extend the time, but I would ask that if there are only going to be 2 questions allowed, that we try to strike a balance between asking questions that may be favorable to both sets of opinions that may be present in the room. And whether it's asking me or recognizing another member of my caucus or of the other caucus, I think it's important that we have a balanced approach to questioning, and this I do not believe has demonstrated a fair balance in terms of questions being addressed to the agriculture business relating to this legislation.
Well, I appreciate the ladies' input, and now that we're spending a little more time on it, in the previous hearing when the author went ahead and went through section by section, I think we went through a full process of questioning on behalf from anyone who was actually in attendance at the time, not including the minority leader. And we went ahead and didn't strike that balance, and it's certainly the reputation of this committee, and I hope of myself, of providing that balance. But we do have to keep the train on the track, and I appreciate the gentlelady's suggestion. Mr. Tolar, thank you very much.
Thank you.
Let me ask D.A. King of the Dustin Inman Society to come on up. Mr. King, we will admonish you as well if you can keep your remarks limited to 5 minutes. We did go longer. However, it is the agricultural industry. I don't think anybody will go ahead and begrudge us that. And then we'll leave some time for questions.
Yes, sir, Mr. Chairman. Thank you very much. Please let me respectfully note that I could easily go as long as Mr. Tolar with a 180-degree different presentation. Good morning. My name is D.A. King. Mr. Chairman, members of the committee, I am president of a self-funded organization called the Dustin Inman Society. We are a group of citizens and real legal immigrants who have taken a pro-enforcement position on America's very liberal immigration laws. Because I'm limited to 5 minutes, I'm probably not going to use the prepared remarks. This, for me, is very much like being stuck in the movie Groundhog Day, Mr. Chairman, in that I was in this very seat in 2006 when we ran the Georgia Security and Immigration Compliance Act through this very committee in this very room. In 2006, the state of Georgia passed a law that was intended to create an atmosphere in which everybody in Georgia would not only comply with, but local governments would help enforce the existing federal immigration law. I find it very interesting that on the one hand people are saying that this is a federal law and the state of Georgia should leave it alone, but then the federal law can be used as a crutch sometimes. Before I begin, I wanted to point out a couple of facts. The state of Georgia is number 6 in the nation, according to the Department of Homeland Security, in the population of people in this country illegally who are properly called illegal aliens. We have more people here illegally than does Arizona. We are number 1 in the rate of increase of the population of illegal aliens from 2000 to 2009 at 114%. Arizona's was somewhere around 45%. The Pew Hispanic Center recently came out with figures that estimates that the workforce in Georgia that's illegal is somewhere around 7%. And I don't remember the last figures. I'm sure everybody knows better than I, but unemployment in Georgia is either 10 or 9.4%. I've lost track. My position and most Georgians is that if there is one Georgian going without a job because anybody in Georgia is ignoring the federal immigration laws that are not enforced, then it's too many. And I respectfully submit that not only does the Georgia legislature have the ability and the right, but very respectfully, I think the duty to do everything it can, including enforce the laws we've already put on the books to protect the American worker. And I think equally as important, if not more, to protect the jobs and the benefits and the services for the real legal immigrants who obeyed our laws and joined the American family lawfully, like my sister. And while I'm at it, from experience, I can tell you, members of the committee, that you will hear people testify and use the word immigrant. And what they're really talking about in most cases is somebody here illegally. And it's deeply offensive to me for people to mix the word immigrant with illegal alien. It's insulting to our immigration process. Mr. Chairman, members of the committee, there are many states in the country who are passing laws similar to what Arizona did recently. The whole world is watching. The whole world is watching to see whether or not Georgia is going to become a pro-enforcement state on our employment laws and immigration, or an anti-enforcement state. We cannot be in the middle on this. The federal government has refused to secure our borders and to efficiently enforce our immigration laws. That's not a mystery to anyone. You will hear from many people who will tell you, as did your last witness, that there are various reasons for not enforcing our laws, and they will use E-Verify as an example. I have been an authorized E-Verify user since April of 2005. The concept that E-Verify is not accurate is easily disproven from very recent information from the Department of Homeland Security. The little pie chart paper that I just asked to be passed out that you should have in front of you is also reflected on this graph here. The pie chart shows the efficiency level of E-Verify, and I heard somebody a moment ago say that E-Verify was either 50 or 80% inaccurate. That is no more true than I might stop on the way home and buy a hairdryer. It is complete fantasy. But it's numbers that are constantly put out both by the media and in the media to throw people off. These numbers are easily recognizable to demonstrate the efficiency of E-Verify and its accuracy. This is a list printed from date of 3 September in very small print of E-Verify users here in the state of Georgia. More than 16,000 companies are listed in that book, again, as of 3 September of last year, of employers who are voluntarily using this system. Now, they have put themselves on an unequal playing field. They have created a sense of integrity in their own business, but they still have to compete with other employers who don't use E-Verify, who can hire cheap black market labor that has escaped capture at our borders. I have traveled the state since 2007 when the 2006 law went into effect, speaking to local governments and official agencies and checking on compliance. I did that at my own expense because there is no oversight agency in the state to monitor or educate local governments on compliance. I'm happy to answer a question on that, but I wanted it to be clear that the use of E-Verify is a deterrent. It's very effective. And the reason that a lot of very powerful lobbying groups don't want E-Verify used is because it is so efficient. Every business that uses E-Verify is bound by the law to have one of these in their office that's that's clearly visible to anyone who comes in. It is a huge deterrent. A very small amount of the people who get a negative response from E-Verify after being hired ever come back to contest that because they're here illegally and they've been caught, and they go down the road to an employer who's not using E-Verify. But this is what goes up in an office, and it serves as a deterrent. If I may have one more minute, Mr. Chairman, the H-2A visa, which has successfully remained a secret for a large part of this debate, does not have any limits to it. I want to say that very carefully. The agriculture industry nationwide, including here in Georgia, has the ability to lawfully import as much temporary, legal, foreign workers as they would ever need to work in our agriculture business. Mixing up another visa that does have a limit with the H-2A, while it may be good politics and rather slick presentation, has absolutely no basis in reality. The argument that Georgia somehow cannot afford to enforce the law is insulting to the millions of Georgians who cannot be here today, who are howling to be protected by their state government from the ravages of the crime of illegal immigration and illegal employment. That anybody in Georgia would hire illegal labor while our countrymen are standing in the unemployment line says a lot about where we have gone as a country. Again, the world is watching. I hope that not only this committee, but the legislature as a whole will make the decision to become a strict pro-enforcement state, protect the American worker, protect the real immigrants, and honor the tradition of immigration into our country. I don't know if that was 5 minutes or not, but I'm happy for any questions.
It was actually 10, and as a result, your time has expired, but we appreciate your coming down here today and offering testimony, and we're going to reserve the right, as all members should, to ask questions and later on offline and to provide us additional information if you see fit.
Thank you for your time, Mr. Chairman. If I may, and I hope this doesn't count on anybody else's time, there is a deputy here from Gwinnett County Sheriff's Department who I forgot to make known to the chairman at the beginning of the meeting, and I apologize. His name is John Spears.
Deputy Spears, wherever you are, thank you for your service. Let me call on Judith Martinez Sadri. If I'm mispronouncing that, I apologize, on behalf of Galeo.
I'm getting her.
Oh, okay. I'll tell you what, while we're waiting for her, let me go ahead and recognize Kyle Jackson with the National Federation of Independent Business. I know, Ms. Jackson, you were up in the mezz and came on down, and then we'll have Ms. Martinez Sadri in the on-deck circle.
Thank you, Mr. Chairman. I apologize to the members of the committee. I ran off this morning and forgot copies of my written testimony, but I have emailed it to the chairman's office, and I'll be happy to get that to all of you either later today or tomorrow. I will be brief. My name is Kyle Jackson. I'm the state director for the Georgia chapter of the National Federation of Independent Business. Thank you for the opportunity to be here today to provide interested party testimony on House Bill 87. Before I get to my comments, let me speak briefly to NFIB Georgia and who we represent. We are the nation's and state's largest small business advocacy organization with 8,000 small employers here in Georgia and about 325,000 small employers nationwide. We are a member-driven organization in that before we take a position on any piece of legislation, state or federal, we poll or survey our members as to make sure the organization always represents the true position of small business. House Bill 87 is a very large, comprehensive, and complex piece of legislation. Credit to the sponsor, Representative Ramsey, as well as this committee for tackling such a difficult and important issue. The legislation contains many topics that don't have a small business impact, and I'm not in a position to comment on those areas of the bill. I can, however, provide you with some perspective on the provisions of the bill that do impact small business. As an organization, our members consistently and vociferously oppose efforts by government at any level to enforce mandates on small business. However, my members have identified illegal immigration as an area where they support tougher sanctions on employers who knowingly, keyword being knowingly, hire illegal workers. On the 2011 NFIB Georgia member ballot, 77% of respondents supported stiffer penalties on employers who knowingly hire illegal immigrants. This result is consistent with the calls and emails I have received from honest, well-intentioned employers who are competing on an unfair playing field with employers who cut corners and employ illegal labor as a cost-cutting measure. That isn't to say I don't have concerns about the legislation. E-Verify, while as an improved free and online tool, is not perfect, and mandating its usage does add another layer to the regulatory burden on small employers in this state. Furthermore, it is important that the legislation provide ironclad protections for employers who use E-Verify to protect them from future actions in the case of a false positive in the system. I also recognize and appreciate Representative Ramsey's efforts to exempt employers of 5 and under in the bill. Regulations and compliance are a very serious challenge for the smallest of Georgia's businesses. In closing, I would suggest any action taken by the legislature ought to be coupled with an education and outreach program to help ensure compliance in the small business community. Phasing in employers over time, as House Bill 87 would do, does allow for a period of education, and I hope the state would be a partner with NFIB in reaching out to the small business community. I know this legislation is a continued work in progress, and I appreciate the sponsor's willingness to entertain input and suggested improvements. Thank you again to the committee for considering small business and allowing me the time to discuss this legislation. I would be happy to answer any questions.
Thank you, Mr. Jackson. Any questions for Mr. Jackson of the NFIB? Mr. Setzler.
Thank you, Mr. Chairman. Again, and this is a question that could be also directed to an agricultural business, much like many of your members. But when Mr. Tiller was here earlier, he talked about his business owners being very capable of signing up for the system, even the small ones. He recognized it's a relatively trivial amount of time to register for E-Verify, maybe 20 minutes, and maybe 30 seconds per check per employee. Looking at this chart that shows the 85% of folks that are identified as not being eligible through the E-Verify system don't pursue action, shows the level of effectiveness. I wanted you to comment on the capability of a small business, whether it's got 6 employees, whether it has 2 or 3 employees. Aren't they really basically run the same way? And isn't it really just the same for a business with 2 or 3 employees as it would be for a business of 6 or 7 employees?
Well, to answer your question, Representative, all small businesses are unique. There are certainly common themes and trends when it comes to hiring practices. It's hard to get in the mind and in the operations of a really small business, because you keep in mind, anytime you're taking a person at a 3-employee, 4-employee, 5-employee shop away from the actual running of their business, that's time that they're not spent generating, tax revenue for the state or jobs for the state. It's somewhat of a concern. I have heard.
But given the 30 seconds to do an E-Verify check relative to the other Social Security registrations and things for employers, wouldn't you agree that the 30-second check is a trivial amount of time?
I don't think that's an insurmountable burden.
Thank you.
I see no further questions. Thank you, Mr. Jackson. Has Ms. Martinez Sadri entered the room? Am I saying that right? Sadri?
Yes, that's correct.
All right.
You got that right.
Ms. Martinez Sadri, I know you're speaking on behalf of Galeo.
Yes.
We're allotting everyone 10 minutes. If
That's
you could,
I'll be brief.
limit your comments to 5, and then that would allow a few minutes for questions, if you can. But
sure.
that's up to you.
Yeah, I'm speaking on behalf of the Georgia Association of Latino Elected Officials. Thank you for the opportunity, Mr. Chairman and committee members. My name is Judy Martinez Sadri, an entrepreneur, an engaged member of the Latino community, a mother, and a Georgia taxpayer. You want me to be louder? You want me to start all over? Good. It's good practice. Good morning, Mr. Chairman and committee members. Thank you for the opportunity. My name is Judy Martinez Sadri, a Galeo board member, an entrepreneur, an engaged member of the Latino community, a mother, and a taxpayer. I'm here to provide testimony on behalf of Jerry Gonzalez, Executive Director of Galeo. Unfortunately, he's out of town and he cannot be here with us today. But this is what he wished to testify before you today. Last Friday, this committee began the consideration of House Bill 87, a copycat version of the controversial Arizona immigration law. Despite the fact that similar legislation across the country is being delayed due to serious economic concerns, and that such laws have been challenged by federal courts and the Department of Justice, Georgia's legislators insist on moving forward with their immigration enforcement law. The passage of such a controversial legislation would be fiscally disastrous for our state on a number of fronts. To begin with, any state regulatory scheme of immigration enforcement will require scarce resources for implementation. Georgia, like many other states, is in a serious fiscal crisis and considering budget cuts. How can the state come up with resources required for an implementation of such an expensive immigration enforcement law? How much will Georgia have to pay for the potential litigation costs associated with the future lawsuits? In addition, Georgia has worked hard to build a business and investment-friendly image that would be harmed by passing such as anti-immigrant laws. Our state is the home of many multinational corporations. It has the world's busiest airport. It has a thirst for expanding international trade and is the cradle of the civil rights movement. Passing such a law is a step backward for Georgia. Georgia's economic development efforts rely upon it being seen as a good place to do business. If HB 87 moves forward, that reputation will certainly be irreparably tarnished. The tourism and convention business is very important to the city of Atlanta and to our state as a whole. It is our state's second largest industry and has a total economic impact of about $34.8 billion. In 2009, $1.8 billion was spent in Georgia from foreign travelers in direct expenditures. For every $1 million spent by international visitors in our state, it creates 11.5 new jobs, generates over $330,000 in payroll, and generates over $123,000 in state taxes. If HB 87 moves forward, the international community will get the message that they are not welcome to Georgia, and therefore our state will not only lose millions of dollars, but will also be known internationally as a hostile state towards business and foreign investors. Georgia's leading industry is agriculture, which generates $65 billion annually toward the state's economy and employs 1 of every 7 residents. U.S. Senator Saxby Chambliss has estimated that our nation's agricultural workforce is made up to 50 to 70% undocumented immigrants. Because of these facts, the Georgia Farm Bureau has weighed in opposition the consideration of an Arizona copycat legislation for Georgia. In fact, Georgia Senator Jack Murphy has proposed exempting our vibrant agricultural industry from any immigration enforcement or regulatory consideration such as HB 87. It is a move that certainly points to the hypocrisy of the rhetorical enforcement of the rule of law mantra and the practical impact on the industry. The solution to our immigration crisis is in reckless and harmful legislation. It lies here in our Gold Dome leadership, working with Georgia's congressional delegation and President Obama to help overcome the impasse on immigration reform and to develop a bipartisan, workable solution through Congress that will move our nation forward, while also upholding our values as Americans. The Arizona copycat legislation is a job killer for Georgia. My fellow Georgians, we can and we must do better than this. Again, this testimony is on behalf of Jerry Gonzalez, Executive Director of Galileo. Any questions that I'll be asked, I'll be answering as a regular citizen, like I said, an entrepreneur, a business owner, and a mother. And I'm just add, and I hate reading, but I had to do it. I just want to tell you that I moved to Georgia 14 years ago, and this is my home. I'm originally from Mexico, but I made Georgia my home, and I'm so proud to be Georgian. And it really hurts me, and it bothers me that we're spending time trying in the 21st century trying to discuss such a laws that will just take us backward. Let's be open like many other cities around the world who are looking for opportunities to expand their business and to be part of this global economy. Thank you.
Thank you, Ms. Martinez-Sadri. Do you want to answer a question, or would you prefer not to?
I would answer a question as
okay,
as
you have 3 minutes left, so I'm going to call on Mr. Pack.
Thank you, Ms. Martinez. During your written reading of, I guess, Mr. Gonzalez's testimony, you stated that passage of some such laws or Arizona copycat laws result in fiscal damage or destruction to the state. The state, as I understand it, right, as of right now, on previous testimony, that there's already a similar statute, just not being enforced in 2006. So what is the basis for the additional supposed economic loss that you're citing? If the law exists, all we're doing is to put enforcement mechanisms to a law that already exists.
Sure. Well, I have to say that I'm no lawyer here, so I'm not very familiar with all your lingo and all, the way you guys ask, but I'm just a regular citizen like many others out there, and I see that our state has many other issues, and our teachers are not getting paid. There are a lot of cuts everywhere, so where is the money for those laws? In the last legislation, other laws were passed that are not even enforced. So why are we turning around here, just wasting our time trying to implement laws that won't get enforced? And where's the money? I mean, clearly this proposal is a copy of the immigration of the Arizona law, isn't it? Are they successful? No. Why are we following them? Why are we doing something that hasn't given results? Let's let our federal government do what they're supposed to do. Is that okay?
Thank you. Ms. Martinez-Sadri, your time has expired. We appreciate your taking the time to be here this morning. Let me call on Mr. John Ciancia, Jobs for Georgians. Am I pronouncing that last name Okay, 2 for 2.
Awesome.
And again, you're under the 10-minute rule as well. We appreciate
Yes, sir.
your taking the time to be here this morning.
Yes, sir. Thank you, Mr. Chairman. I appreciate representatives. My name is John Ciancia. I'm with Jobs for Georgians, and we are a group of Georgian workers, mainly in construction, that have gone around and they're sick and tired of being shut out of our work in the state of Georgia. We have gone all over the state, and we've exposed Cobb County last year of just being shut out because we're not we're regular Georgians and tax-paying citizens, and we feel that the construction industry has really been decimated with these illegal immigration and illegals working on these construction sites, that we've been shut out. Again, we're working with Fox 5. It was on last night. We've uncovered numerous jobs all over the state where these contractors and these general contractors and these subcontractors, they know what's going on. I'm not going to sugarcoat it. We are getting shut out because of our wages. They are using these folks, abusing these folks, and paying them a lesser wage. And this is what's happening all across the state of Georgia right now in the construction industry. And we are sick and tired of it. And we are not going to stop until this bill goes through. We are for it. We hope it passes. Everybody should E-Verify, and that's it. That's who we are.
We appreciate your taking the time to be here this morning. Would you like to answer questions
Sure.
from members of the committee? Mr. Ramsey.
I actually I pushed the button, and then in your subsequent testimony, you kind of got at the point I was going to ask you to make. But I just appreciate you coming down here. I think you live in my district, don't you?
I absolutely live 30 houses away.
But who's
and
counting?
I do apologize for I'm not usually in this setting, and I thank you very much for.
No, it's we're grateful for you to be here, and whether it's on your side of the issue or Ms. Martinez-Sadri's side of the issue, we appreciate
Right.
input from across the state.
Sure.
We are where we are. We agree. We disagree. Sometimes we agree to disagree. The hope
Right.
is that we can do so without being disagreeable,
Right.
And represent our constituencies respectively.
Thank you.
So, I see no further questions. Again,
Thank you.
We appreciate
Thank you
your
very
coming
much.
down.
Appreciate it.
Let me call on Mr. Arnie Geiger, representing the American Legion. Mr. Geiger?
Thank you, Mr. Chairman.
No, I think the first thing I need to do is thank you, isn't it? Don't I? For your service.
I appreciate that. I just want to thank the committee for working hard on this, and particularly Representative Ramsey. The American Legion opposes any person or persons being in this country illegally, regardless of race, sex, creed, color, or national origin. We believe that the current laws governing immigration should be impartially and equally enforced. However, unfortunately, the federal government is not doing that, and so I see the need for Georgia to come forth with laws under the 10th Amendment of the Constitution. The American Legion members have served the United States around the world, and Americans, so that Americans can be safe here at home. They know third world countries. We've seen poverty, we've seen political instability, we've seen disease, and we've seen war. And the sacrifices that the American Legion members, veterans, American Legion veterans have made gives them a little bit different perspective on national security issues than many other Americans may have. Legionnaires described a creed to uphold and defend the Constitution of the United States of America and maintain law and order, and to foster and perpetuate 100% Americanism. That's not just words. Those are the things that veterans do, not only when they're in the service, but after the service. So American Legion has been a leader in mentoring candidates who want to be legal citizens. We've done a lot of work in that particular area. But we are definitely not in favor of illegal immigration. Illegal immigration under the federal law is Title 8, Section 1325, which I'm sure most of you are familiar with, is very precise and very clear what the law is in that. And one of the questions that was brought up here earlier today is simply stated in the federal law, and this law, HB 87, is going to simply back that up. Very clearly it says in that section 8, it says anyone employing or contracting with an illegal alien without verifying his work authorization status is guilty of a misdemeanor. So we need to have the E-Verify. Unfortunately, the cost of illegal immigration, they're saying that Georgia is going to lose a lot of money by enforcing this bill. But on the contrary, the cost to the state is enormous, and since the cost of illegal immigration in terms of government expenditures, education, criminal justice, and medical care, these costs are staggering. California alone is over $10 billion a year. That's half of Georgia's budget. And unfortunately, since the states must pay this high cost of providing such services, illegal immigration has become one of the largest unfunded federal mandates. The agricultural concerns in this state, that's our biggest industry, and we certainly appreciate everything they do. I was born and raised on a farm myself, and I fully understand farm labor. However, the illegal immigration population overstays their visa. Over 50% of the illegal aliens in the United States have had a visa at one time, but now they overstay it and pay no attention to returning as their visas have suggested. So we have a real problem with that particular end of the industry. The E-Verify program certainly would help that particular situation. Crime, I don't have to talk about crime. I'm sure that all the people in this room are familiar with the crime that the cost of the crime and the insecurity to the citizens of Georgia that illegal aliens have brought here. Education in Georgia is a very sticky point, and we have put a lot of money into education. And the Supreme Court ruled prior and Doe in 1982 that we must, as a state, we must educate the people, the students of illegal aliens. So the court noted that decision that the Congress could reverse that decision if illegal alien students proved to be a financial hardship to the taxpayers, and if the students of legal citizens were having their education negatively impacted. But unfortunately, Congress has never taken that step, because that is exactly what is happening in our state today. The proponents to open borders and guest workers, amnesty programs say illegal immigrants take jobs that Americans won't do. That is absolutely not true. And what it is that is a demeaning to the general population of this country, and it's a demeaning to legal immigrants. People who have come here legally to work are being put out of jobs because of illegal immigration. I feel that we need to go forward with this bill, and I believe it is well written and will upstand the constitutional test. Thank you, sir.
Thank you, Mr. Geiger. Your time has actually expired. I want to thank you for taking the time to be heard this morning. And would you share with us where and when you served the country?
I served during the Vietnam era. I was not in Vietnam, but I was in England, France, Germany, North Africa, Norway, and a few other places.
Well, thank you again for your time and for your service. Let me call on Frank Mulcahy with the Georgia Catholic Conference. I think I just saw him walk in. There he is. Mr. Mulcahy, good morning. Thank you for
Mr. Chairman.
Taking the time to speak with us. You're under the 10-minute rule like everyone else is, and if we have any extra time, look forward to the possibility of questions after your comments.
That's fine, Mr. Chairman. I appreciate it. I also appreciate the opportunity of having a separate room for some of us to listen by streaming, so thank you for that. My name is Frank Mulcahy. I am an attorney. I am also the executive director of the Georgia Catholic Conference. The Georgia Catholic Conference is the spokesperson for the Catholic bishops of Georgia. We currently have in the range of 950,000 Catholic people in the state of Georgia, divided into two dioceses, the Archdiocese of Atlanta with Archbishop Wilton Gregory as the Archbishop, and Bishop Luis Zarama as the auxiliary bishop, and Bishop J. Kevin Boland, Bishop of Savannah. They have asked me to testify this morning, and I will give you a brief statement of where we stand on these issues. The Catholic Church has been involved in these issues, well, for hundreds of years, actually.
So there's some history there.
There's some history there. There's some history there. As far as the current status of legislation, we have been very actively involved with federal legislation. As some of the previous speakers have said, we do support comprehensive immigration reform as a way to solve a very complex problem. We come really in two aspects this morning. First, we come because we have a firm belief in the dignity of each and every human being, whether they have documents, whether they do not, whether they come from the United States or they come from any other country. Every person has inherent dignity and rights, and we support those rights, and we would oppose any legislation which would demean a people or any individuals. Secondly, we come here because we are a very large provider of charitable services in the state of Georgia. We have schools, we have hospitals, we have night shelters, we have emergency food services, we have pregnancy care centers, we have social workers. We deal with virtually every type of person who may come out. We do not discriminate on the basis, and nor could we, would we, or could we discriminate on the basis of race, color, or any other aspect. And so coming from those two places, I would like to direct my comments to several provisions of House Bill 87. I think one of our concerns, and this is just an overriding concern, came to my attention by one of our previous speakers who referred to the employment issue, that people are being employed in agriculture and construction and in other industries, and the attraction of the undocumented is they don't they don't have any way of enforcing higher wages. We would support any legislation, it's not in here, we would support any legislation which would increase those wages for all. I think that would help in solving the human problem and also the immigration problem. Second thing, we do have a problem with the term illegal alien. I realize that is a term, but certainly in federal law, we're talking about at least 3 different people. We're talking about people who have committed a felony by their presence in the United States. We're talking about people who have committed a misdemeanor by failing to be inspected when they cross the border. And thirdly, we have people who have overstayed their visas, which is not a criminal penalty. It is only a civil violation. But this legislation lumps all 3 together. Our concern, if we look at, I'm looking in my version of page 6, Article 5, which has to do with the transportation and harboring. I'll lump the 2 together. This is much, much, much broader than federal law. Federal law, as you know, limits it to those who are transporting or harboring individuals in furtherance of violations of federal immigration law. This limits it to people who are acting in violation of any criminal offense, which certainly would include a misdemeanor traffic offense. Speeding, of course, is a misdemeanor traffic offense. Having improper equipment, like broken taillights, is a misdemeanor. So any traffic stop could result in those people who are transporting people being arrested under this provision. Now, who might that be? It could certainly be people who are taking children to summer camps, we have our confirmation retreats. I know other religions have various activities where parents are asked to transport. They would have put their cars at risk. Another area that would be at severe risk is ambulances, private ambulances, ambulances run by organizations other than the city or the county. Example, we run night shelters. Occasionally we will come across night shelters, individuals who have TB, who have communicable diseases. If the only thing we can do is call the police, and the police can't arrest them, because having TB is not a violation, although it creates a public policy risk, a public health risk, there is nothing we can do because there's no exemption for carrying people for charitable purposes, for health services, or for any other services of that nature. As you may know, our Mercy Hospital, St. Joseph's Hospital, has a Mercy Mobile which is on the streets of Atlanta every night. Every night they're on the street taking people in who are hurt, who are in any way sick. Another area is the harboring. I think that's sort of the same principle. It is much, much, much broader than federal law. And I think the questions would be raised, and not just for our denomination, but any church or any organization which has people who may be overstaying their visa would be subject to criminal penalties. This, I think, is far, far in excess of what this situation really requires. A third area, or I can live up to my fifth area by my calculations, is concerns about other foreign nationals. We have on page 8 under, I guess, section 8, those sorts of identification, forms of identification which people can use to justify their existence in the United States. Those things are very limited. Certainly Georgia driver's licenses. But, we have a lot of conferences where we bring people from many other states and from many other countries. And all of them are not required to have visas. All of them are not required to have these documents. The question would be, can we have these conferences in the future? We have some who travel on diplomatic passports. You're not including diplomats in here. Although you probably couldn't enforce that anyway because of federal law. Another area we have a concern is the limitation on the reporting of crimes. Now, I realize we do have a limited exception in here. The problem is it only covers certain people. Example, we had this, and those of you who may have been at the Violence Against Women conference the other day, we had up in the rotunda, one of the women from our Catholic Charities was testifying about a situation which they have where a woman will be abused in a home or a child will be abused in a home. The police will come in, and they're worried about grandma in the corner. She wasn't a witness. She wasn't a victim. But the next time that child is abused, the next time that woman is abused, they're not going to call the police. The abuser gets away. And this is what we don't believe should happen. We believe in the human dignity of every person, and people who are abused should not be left out in the lurch simply because they may have overstayed their visa or they don't have documentation.
Let me ask you to wrap up,
Sure,
Mr. McKay, if you could.
I know I'm coming right on the edge.
Thank you. That's all right.
The last thing I would suggest, kind of, people may think it's a small one, page 16 on the bill. You do provide an exemption there for people giving services to infants and children. We also think it would be very important to have pregnant women included in there. Mr. Chairman, I thank you very much.
Mr. McKay, we appreciate your taking the time to share your thoughts about the legislation this morning.
Thank you very much.
Let me call on Wendell Phillips, representing the Presbytery of Greater Atlanta.
Thank you very much, Mr. Chairman. And following Frank, as I have done a couple of times, it's always tempting just to say, what he said.
That would be fine.
I know it would. I do want to add a couple of things.
All right.
But my name is Wendell Phillips. I'm the public policy advocate for the Presbytery of Greater Atlanta, which is a governing body of the Presbyterian Church USA. I am an ordained Presbyterian minister. And I really could say pretty much, what Frank said, and leave it at that. But I do want to add a couple of things that may be at least somewhat unique to the Presbyterian, our Presbyterian General Assembly perspective on these. And I'll jump right over all the things I was going to say that was going to sway the day and bring everything to a nice conclusion, and simply report what our Presbyterian General Assembly has said. As others have said, too, and as Frank did say with the Catholic bishops and the conference, the Presbyterian Church USA General Assembly has long held that any laws enacted with regard to immigration, including laws governing undocumented immigration in our country, must be first of all based on a sense of understanding and compassion. The compassionate desire that families be preserved, that they be kept together, in many cases reunited when they are broken apart by occasions when arrests are made. We do have a lot of information regarding when this happens, when children are quite often left alone for long periods of time, when parents are arrested at work. These kinds of things. I would hope that any kind of legislation that is considered here for us would include an understanding of what happens to the families that are involved when the police or ICE or someone else does extend the law to the arrest level, and what happens to the families in those cases, especially to the children. Like many other groups, our Presbyterian General Assembly has supported for many years, for a number of years at least, the work at the federal level to create a responsible, meaningful immigration reform system that is fair and equitable and comprehensive. We have reams of letters that our General Assembly moderators over a series of years, our stated clerk of our General Assembly, have sent to Congress and even to the President, urging that comprehensive immigration reform be accomplished. This covers, of course, as you know, Republican and Democratic administrations, and we remain, very much in support of that taking place. Just one last comment, and that is that our last General Assembly, the 219th General Assembly, which met last year, felt so strongly about these issues, especially in light of the fact that during this time we've had the measure from Arizona, Senate Bill 1070, now one in Kentucky, very similar to ours, I think, Senate Bill 6, I think, in Kentucky, and now our House Bill 84, House Bill 72, and also Senate Bill 40 that we're looking at. They felt so strongly about this that by a supermajority vote, the General Assembly asked our entire denomination to refrain from even holding national meetings in states that have enacted such laws. That's not to say that that's a threat, from our General Assembly. When our General Assembly has met in Atlanta, as it has on occasion, we're not exactly some of the biggest spenders. We don't add to the economy as much as some other conferences, other folks and businesses who meet here, but we do spend money. It is in moderation, of course, but we do like to do that. And this is not a threat from our General Assembly to say if you pass this, we're never coming back. But this is just to show the level of concern and seriousness with which our General Assembly has approached issues such as these. One of the primary fears is that since we are such a multicultural denomination at so many different levels, and when we meet with our General Assembly, we have guests who come from around the world. The General Assembly leadership simply doesn't want to take the risk of them being perhaps harassed or put in some compromising situation because they're in a place where laws may be of such a nature that they could be impacted upon. So I thank you very much for this opportunity to speak. I especially thank Frank again for preceding me, for making so many good points, and I'll answer any questions that you may have, except for the ones that you were going to ask Frank.
Ms. Neal.
Thank you, Mr. Chairman, and thank you for being here. I just wanted to make a comment in reference to when you referenced what would happen to the children. Being a part of law enforcement and just knowing our common practice, whether a person's a citizen or not, and especially if a clause is not added into the bill, the only option that local police would have, I can't speak for federal or GBI or anything of that nature, but the only option local police would have, if no other family member is available to take the children at the time of an arrest, those children will have to go to DFACS. That is our only option for local police. And from there, they'll be in the DFACS system, and they'll go through that. They'll go through that process like any other child would, whether the child is a legal immigrant or not. Because I'm not familiar with the practice of where a illegal child stands under this bill or any other similar bill that we might have in place already.
Yeah. Mr. May I ask a question of Representative Neal?
Sure.
On that line? Are you aware, and I know you're in law enforcement, do you know of any responsibility for informing other family members or taking the time, when a situation arises just like you described, where a child is left alone or more than one child, does law enforcement, I know they have to take the child to DFACS if there's nobody else present. Is there some process by which they can inform other family members so that that step of the way wouldn't necessarily have to be taken?
Now, when it comes to the DFACS side, I'm not familiar with that because for the most part, once DFACS gets involved, we're kind of cut off at that point. They handle it based on what their protocol is.
Mm-hmm.
But as far as the law enforcement side, like I said, if there's no immediate family member to aid in where the child should be or where they should be put, that then falls on the DFACS to be responsible for placement with a family member or a non-family member.
Yeah, I think we would be very, very happy, if there could be some type of inclusion in a bill such as this that would act as a protector, for children in situations like that, or for whole families. Just an acknowledgement that we know what is possible to happen, and it's very seldom good, that there be some kind of protection for that be in a bill such as this, because I think somebody said a while ago that it is a compliance type bill. It's not necessarily punitive, but for the families that are directly affected by this, and for the undocumented immigrant who may be arrested or detained, it is punitive, and that would be something that would help us look at this bill a lot differently.
I understand. Thank you.
Thank you, Mr. Phillips. We appreciate your testimony this morning. Let me call on Dave Allen Grady with the United Methodist Church. Good morning, Mr. Grady.
Chairman.
Good morning. Thank you for being with us this morning, and I'll ask you to confine yourself to 10 minutes or shorter if you'd like to answer questions after your presentation. That's up to you, though.
I won't be very long.
Okay.
I commend y'all for y'all's hard work. It's a daunting task, and also to Representative Ramsey for shepherding this process, and thank you for the great conversation with me. I appreciate that. There are, I could just say ditto and get up and be done. And going after Wendell is kind of like seeing preach after one of your famous preachers. Our denomination has several documents that has been approved repeatedly over the years about immigration, and I have forwarded those on to Representative Ramsey as this bill was put together. I would like to share a resolution that was adopted by the United Methodists that meet in Athens every year, that represent the 1,000 churches in North Georgia. Just the bullet points. I'll forward the whole resolution on to your office if that's okay. The United Methodists in North Georgia are not for an open borders policy or general amnesty, but we are for providing a path to citizenship. Opportunities should be provided for undocumented immigrants currently living in the U.S. to receive work permits and travel permission and access educational opportunities once they undergo background and security checks. There should be fair and consistent process for persons wanting to settle in the United States to pursue permanent residence and citizenship. To protect workers, to replace the deadly, chaotic, and illegal flow of workers to jobs. Let me stop and say that the section on criminalizing the trafficking of human beings is amazing. Thank you. There needs to be wider legal channels so needed workers can be admitted legally to fill available jobs, to avoid the exploitation and abuses of flawed guest worker programs. The nation needs a worker visa program that adequately protects the wages and working conditions of the U.S. and immigrant workers. It should also allow workers to change jobs, meaningfully enforce both the program's rules and existing labor laws, protect law-abiding employers from unscrupulous competitors, and provide a path to permanent status. Reunite families. Immigration reform will not succeed if public policy does not recognize one of the main factors driving immigration, as well as one of America's most cherished values, family unity. Restrictive laws and bureaucratic delays too often undermine this cornerstone of our legal immigration system. Those waiting in line should have their admission expedited, and those admitted on work visas should be able to keep their nuclear families intact. And lastly, to restore the rule of law and enhance security. Enforcement only works when the law is realistic and enforceable. This can be best achieved by a comprehensive overhaul that combines reform, a path to permanent status for immigrants here, and wider channels for those coming in the future, with effective enforcement. A viable enforcement regime should include smart inspections and screening practices, fair proceedings, efficient processing, as well as strategies that crack down on criminal smugglers, get tough with law-breaking employers, and reduce illegality. Such a system will be better enable this nation to know who is already here and who is coming in the future, and bring our system into line with our tradition as a nation of immigrants and a nation of laws. And then et cetera, et cetera, et cetera.
Thank you, Mr. Grady. Would you like to answer some questions from members of the committee?
Sure.
Mr. Ramsey.
I wait,
Ms. Abrams.
Thank you, Mr. Chairman. I just have two questions. One speaks to the conversation about punitive nature of the bill, and while I recognize that by and large it is more compliance oriented, I draw your attention to Section 7, which would require the forfeiture of vehicles used in the transportation of any person captured under this bill, would it be your understanding that that would apply to church vehicles or the vehicles of nonprofits that are being used to provide services such as domestic violence support, homeless support, those types of charitable behaviors that require the transport of persons that you may know to be undocumented?
Representative Abrams, I do not know exactly. I know that pastors, I sit as the chair of the North Georgia Conference's advocacy team, and that's why I'm here today. And the some of the concerns that have been addressed to me by other pastors has been if something like an Arizona-style immigration bill comes into effect in Georgia, that the ability to help the stranger, people coming in our doors and knocking and seeking assistance, might be limited. And so I don't know exactly if that would be prohibited, but I do know that there are concerns over what churches would be able to do in our long-standing tradition of helping the poor.
If I may ask one follow-up, Mr. Chairman. The other concern I would raise is Section 15 or Section 16, the section that provides a safe harbor. Would you and your conference, and as a United Methodist, I'm happy to see you here, would you support a safe harbor that includes victims of domestic violence and persons receiving support services from religious and charitable organizations, which would essentially exempt those persons from being captured under the provisions of this bill?
The other, that hits exactly what the other allegorical piece that I've been emailed and phone called about a lot recently is that there are people who are pastors of churches. One of the fastest growing demographics in the state of Georgia is the Latina community. And as such, the United Methodist churches are starting new churches that are for Latina persons. And so one of the things that's being told to me is I've got people that are afraid to come to church.
Thank you.
Mr. Sessler.
Mr. Chairman, just a quick statement. Again, I would encourage you. I know we in the legislature we debate concepts, but we vote words on a page.
Mm-hmm.
Would you characterize this as an Arizona-style immigration law? I ask that as a rhetorical question because there are vast distinctions between this, and I know as in your role of advocate for a church and a denomination in which I was married. I was married to United Methodist Church, so I appreciate your being here. I would just caution you to be real careful about the quote Arizona-style immigration law that conjures up, for a number of reasons, right and wrong, notions of profiling and those kinds of things. There's nothing in this bill that does that, and I appreciate your being here. I just wanted to caution your use of that because I think it's not helpful, and it's frankly, although I know unintentional, misleading when really looking to get into the crux of what's really in this bill. So.
Thank you.
Mr. Grady, we really do appreciate your coming down.
Can I add one more thing?
Sure.
Our General Commission on Religion and Race has a campaign going right now that says drop the I word. And what it's encouraging United Methodists to do is to stop using the word illegal as an adjective for persons. There is illegal unemployment. There is illegal immigration, but there is no illegal child of God.
Thank you. Ms. Melanie Velez with the Southern Center for Human Rights. Thank you very much for appearing this morning. Welcome back. We've seen you before, and welcome back.
Thank you for your time. I appreciate being here. My name is Melanie Velez. I'm a managing attorney with the Southern Center for Human Rights, and I wanted to focus my comments today, I realize I must be brief, on an area that we've worked on at the Southern Center for about the past 30 years, and that's the area of jails and prisons. One of the concerns that we have at the Southern Center about the current draft of the bill is the potential impact on jail conditions and jail facilities throughout Georgia. We at the Southern Center have monitored a consent decree that's currently before Judge Shube in the Northern District of Georgia since about 2004. As many of you may know, the Fulton County Jail has had continuous problems regarding the number of people in their custody. And we believe that several provisions of the current legislation will contribute to the problems that the Fulton County Jail and perhaps many others are having. I want to focus on a couple of things that we've learned through our time at the Fulton County Jail. Currently, the population at the Fulton County Jail is 3,002 people. Its capacity is about 2,500. Fulton County Jail continuously is unable to house all of the individuals in their custody, so they must continuously outsource. There are about 330 individuals currently outsourced, and by that I mean individuals who are in the custody of Fulton County Jail but must be transferred to be held in the custody of other jail facilities, including, for example, Hall County. The overcrowding issues at the Fulton County Jail breed other concerns that will perhaps and likely be exacerbated by the additional criminal violations that are created by the current draft of the bill and by encouraging the use of 287Gs. I wanted to highlight three concerns that we've seen again and again at the Fulton County Jail, and that is first, security issues, second, public health concerns that we heard alluded to earlier in a different context, and third, due process considerations. With regard to security, the population at the Fulton County Jail, as in numerous other jails throughout Georgia, is so high that the sheriff and county administrators and the jail administrators themselves are continuously challenged at being able to separate individuals that pose a danger to one another. Recently, Fox News reported on the beating injuries that a detainee there experienced simply because the jail doesn't always have the capacity to separate out individuals that may pose a danger to one another. Overcrowding feeds this concern. Second, with regard to public health, although the sheriff and others in the jail administration certainly make good efforts to try to process all the individuals that come into their custody very quickly, what happens in the there's an area of the jail when someone first comes in where they're detained for a certain period of time while they have TB tests and other mandatory testing that's required by state law. There's often such a backlog there that individuals end up sleeping on the floor. There's not the capacity to be able to transfer individuals to beds quickly. And this is certainly exacerbated the higher the numbers go in the jail. Lastly, there are due process considerations. The Southern Center has been involved in 2 suits against the Fulton County Jail. One of these suits was prompted by the jail's incapacity to quickly release individuals once there was no longer a legal basis for detaining them. Our experience has been, not only at the Fulton County Jail, but in other state jail facilities, that once you introduce immigration detainers into a jail facility, it becomes quite a challenge. And individuals often can be over-detained. I'm not saying this occurs all the time, but certainly it's an additional burden on the jail system, which in our experience they haven't proven to have the capacity to handle in facilities that are already overcrowded and overburdened. I will leave my comments at that. We just wanted to highlight the burden of this legislation, especially on jails, and Fulton County Jail is a classic example of the problems that will be posed.
Thank you for those constructive comments. That is, people can be in different places on a particular issue, but that is, the capacity and the mechanics of the capacity issue as you get into an enforcement look at, this particular issue is absolutely relevant, and I appreciate your bringing that to the fore. Mr. Vice Chairman, did you have something? No? All right. Ms. Abrams.
Thank you. I actually wanted to ask you a question in your capacity as a member of the Southern Center for Human Rights. There was a comment made earlier that this bill does not contain any capacity for racial profiling. However, is it not true that traffic stops, which are, I think it's line 243 and 244, allow a peace officer to stop someone for a traffic offense and use that as grounds for invoking this language? Is it not true that traditionally traffic stops have been a common pretext for racial profiling, and that has been almost universally seen as the sort of gateway to racial profiling among police officers.
You're absolutely correct, Representative. I think that those provisions in Article 5, beginning at line 238, certainly pose that concern. And in our read of the legislation, and I'm not sure that I have the current one, but the line that instructs officers not to consider race or color or national origin are insufficient to address concerns of racial profiling.
I think it would be very unfortunate to go ahead and cast a really wide net as some sort of universal truth that officers engage in that type of conduct, because I don't believe that personally is the truth. Do I believe that that has occurred and does occur and will occur in the future? Yes, I do, but I don't believe it presents itself as an example of some widespread phenomenon or problem that warrants inaction on this issue, just speaking for myself. I see no further questions. I appreciate your time coming in this morning. We really do, and look forward to seeing you again. I'm sure we will see you again on other issues.
I think there are other
All right.
issues.
Thank you.
Thank you.
Mary Kay Woodworth, representing the Urban Agricultural Council. Okay, if she's here and she comes back, we can always come back. Mr. Larry Pellegrini with the Georgia Latino Alliance for Human Rights.
Yes, sir. Noticing the time, since I hang around here a lot, Attorney Duke is here, and I would cede my time or delay to another time to give him an opportunity not have to come back. Is that acceptable?
Well, we've got you down here, and I mean, you're welcome to join us. I know, is it Cook?
Cook. I'll be here Friday morning.
That's fine, Mr. Cook. I also take notice of the fact that you are a board member of Galeo. Is that not correct?
I am a board member.
Okay, we're trying to go ahead and, if we can, limit organizations to one spokesman in the interest of fairness.
I was not speaking on their behalf.
I understand, but, you know, the lines do get gray every now and then, don't they? Yeah, they do. But, you know, we err on the side of more information than less. Mr. Pellegrini, do you want to? You're under no duty, but you can. Mr. Cook, it's not precluding you, but I just want to make sure those lines are clear.
Thank you, Mr. Chairman, members of the committee. Like I said, I am around a lot. I am here on behalf of the Georgia Latino Alliance for Human Rights, and I'm sort of going to go off the original script based on some of the things that that I heard here today. It was really good, I think, to see a progression of people who testified move from some of the more practical issues and technical things that we all have to think about and deal with into some of the effect on people, the human issues, and of course how we see each other and the importance of thinking when we get into this kind of legislation that's so controversial about how we affect the fabric of society. And so I want to turn to, I guess, an appeal that we spend as much time thinking about the public policy that comes out of the words on the page, and think about how it does affect people. I do feel that having looked at many of the issues from racial profiling to E-Verify to the harboring, right of action, the role of law enforcement, that over the years I've learned a whole lot about this, and I would really appreciate the time of meeting with everyone to be in more detail. However, I want to give sort of an example of what I ran into last week. We did hear from agribusiness, and I met with some small farmers, and they were quite alarmed, but they didn't really know how to engage in the process. So it was really interesting to talk to them. Literally, their lives are affected, their businesses are affected, and what they wanted to talk about was how different, and they did see this bill as a model coming from Arizona. And they wanted to be sure. They actually had two messages that they asked me to bring, but they wanted to be sure that if that was the model, that everyone was aware that very different consideration in Arizona. Agriculture and especially small farms play a different role. And the figures that they had showed that Georgia has 3 times the number of farms that employ migrant workers than Arizona does, that the size of the farms are 8 times larger in Arizona, which means that it's more agribusiness rather than family farms and small farms. And the number of farms in the 70 to 99 acre range, there are 11 times more in Georgia. And that message, the point of that for them was that somebody had to say that. And I don't speak for the farmers. I speak from a meeting with farmers. When we talk about our 2 top industries, we do have to talk about impressions. And if the impression is that this is something that has to be done because the federal government isn't responding to comprehensive national reform, we should be putting our energy, of course, into trying to make that happen at the same time. See a dedication from folks to put pressure on the congressional delegation to do comprehensive reform that would eventually solve the problem. Because what we do here, and I realize everybody is searching to see what is within the scope of possibilities for state law, but what we do here is just sort of squeeze in the crevices and do what we can, and ultimately plea for the dedication of folks to see real solutions, because some of these things are really not the solutions that we all want to see, because it on the federal level is something that is their domain. Some of the people that are going to follow who will talk about E-Verify system, and sometimes there's a difference in the kind of business and what the error rate is. It's really on all of the issues, depending on the legal language, it depends the kind of people are involved, the kind of businesses involved, what the problems are with it. And I hope we spend a lot of time talking about that. And the impression of people out there, the first thing we sort of heard about was the fear that people could not have the same relationship with law enforcement if there was this bill that would be passed. They would be afraid. That was the first thing that we heard. So, like I said, I look forward really not to a couple seconds here, but more one-on-one, even if we disagree, to talk about the different effects on people for each of the issues.
Thank you, Mr. Pellegrini. Just a couple of quick points. At the federal, on the federal issue, our federal government has failed on the issue. Republicans on the federal side have failed. Democrats on the federal side have failed. So it's not a partisan issue. It is a federal versus state issue. Our when the federal government displays its inertia over the course of time, states notice that and states act. One other general point, because I've heard it throughout this morning. There's a lot of sensationalism going on. Arizona, this type of bill. One of the unfortunate realities of politics is, number one, people take someone else's example and just presume that we're going to go ahead and follow a particular example, when in fact we are ultimately not. And unfortunately, one of the other unfortunate realities of this process is that when you have, a bill as introduced, which ultimately gets refined over time, but then people want to hang their hat on a provision or two, and there are more than welcome to do that. That's part of the process as well. To use that as some sort of public whipping boy, for lack of a better term, it really just sort of devolves the dialogue. So what we're doing is looking toward a productive piece of work product that will actually be implementable and will survive scrutiny. That's easier said than done, and we're the first ones to admit that.
Right.
But it's important that people understand that we're not Arizona. So,
right. No, I understand.
And our
work
product, and our work product ultimately is what we will be judged by, not the rhetoric of, frankly, people on both sides of the issue.
Right, and I hope I didn't slip and say
no, you didn't. I just
a
want to make sure
partisan.
that, no,
Yeah.
I just want to make sure that
Yeah.
no, you didn't. But I
Yeah.
just want to make sure that's clear for general consumption, Mr. Vice Chairman.
Thank you, Mr. Chairman. You made this statement, something along the lines that people were afraid, I think in connection with the harboring and the transportation and all that. My question to you is, don't you think that somebody who harbors or knowingly harbors, knowingly transports an illegal alien, someone who is intentionally violated our country's borders, shouldn't they be afraid? I mean, they have assisted in the violation of our borders and the breaking of our law. Shouldn't they be afraid?
Well, you know, it depends again. You have mixed status families, and you have people who may not, as we have trouble sometimes communicating with membership, and you all with the general public in doing public education about an issue. You know, there are different levels of understanding of what's happening. Sometimes the first impression sticks, even if it changed. And the folks have a fear because they really don't know what to expect, and they fear the worst. And how do we address that? We have to talk to them. They do, but I go back to saying, you know, I most think about how things affect people, and that's what I hear, and that's what tugs at my heart first.
Well, I understand, but I mean, we can all sit around and feel and, you know, sympathize and all this, but I mean, the rule of law is what we're really talking about here. And you talk about people, mixed families and things like that. Those are conditions that were brought about by the people themselves when they came into the country illegally. They knew what they were doing.
And if we're going to offer remedies, I believe, and try to legislate procedures or policies, then we ought to really, there's some things that just may not be able to be fixed, and how do we address that? We don't want to make a mistake. Well, like I said, I keep going back to, are people going to be hurt? So we don't want to make a mistake. So there are some things that probably ought to be left behind if there are issues that we cannot fix. We just want to try at the risk of making a mistake. And that's where the families come in that that do have a fear for others, that they may be broken up, they may be targeted. All the elements that have been pointed out are controversial in the issue. It's on the minds of folks.
Well, I can only speak for myself. I'm not speaking for anybody else on this committee. But my thought is that, you know, the way to fix it is if you're a foreign national and you're in this country illegally, then the way to fix it would be go back home, go back where you came from. That would be my answer.
Well, we've seen once again, it depends. We've seen the folks that came here to help us build the Olympics. They were told, we have a job for you, bring all your friends, and you know, you'll get your paperwork to become citizens, and that didn't happen.
We're a little bit over, but we'll let Mr. Atwood has been quiet the whole morning, so he's got his light on. If you'd like to be recognized, Mr. Atwood.
Just a short minute, and thank you, Mr. Chairman. I truly believe in, you know, if you wish to be understood, then you first seek to understand. And I have appreciated the thoughtful nature of everyone that's testified. I will tell you that I've served as a little magistrate judge and an attorney, but a large part of my career I also served, Mr. Speaker, as a federal agent working for the United States Customs Service. I can tell you that it was extremely frustrating for us, for the good men and women that worked in that organization. I can remember when I was in South Carolina and we had to cover the entire state during the height of the primarily marine and air drug smuggling that we did, and we encountered many folks that were not here legally. They were bringing those drugs in, and we had 15 agents to cover the entire state, and we welcomed local law enforcement to help us. We welcomed that, and we needed it. We had 2 of our young men that were murdered on the southwest border, and we did not find them until the next day because we did not have adequate radio communication, and we were so spread so thin and covered such a wide area that it was extremely difficult for us to even locate their bodies. And they were shot and killed by a man trying to enforce the law against folks coming in illegally. So just from a personal standpoint, I can tell you, and an experience standpoint, that I think that the effort that we're trying so hard to do and to do constitutionally is important for us, and where we can elicit local folks, I think it's well served that we do that.
Thank you, Mr. Pellegrini. Thank you. We appreciate it. We have one more witness, and that is Dr. Bill Dr. Bill Hudson, representing Georgia Tea Party. And Dr. Hudson, I'll go ahead and say the same thing I've said to everybody else. You're under a 10-minute rule. And we appreciate you joining us this morning and your patience this morning.
Yes, you're welcome. I've got a minute to say good morning, Chairman and committee members. My name is Dr. Bill Hudson. I'm here testifying and making comments representing myself and the Georgia Tea Party. First of all, I'd like to say that I'm here because I support...
Let me ask you, I'm sorry to pull the microphone a little bit closer. Thank you.
Sorry.
Thank you.
First, I would like to say that I'm here because I support immigration reform legislation in the great state of Georgia. First and foremost, the fact that the rule of law of the United States Constitution is being broken with these illegal aliens coming into our country illegally or overstaying visas that have expired. So they are illegally here in our state and have no rights to obtain social government handout programs or to take jobs away from Georgia citizens that are unemployed and cannot find work. There should be stiff penalties for employers in Georgia for hiring these illegal aliens. These people are illegally here, and that needs to end with them being gone sooner rather than later. I realize that this bill is mostly about compliance, but I think there needs to be some penalties in here too to see that compliance happens. After being here on Friday for Representative Ramsey's public debut of his measure, it appeared to me that the brunt of the enforcement for this bill is laid upon the law enforcement agencies across the state. It would seem to me that the enforcement of this legislation should be across all pertinent agencies in the state government. Examples, the Department of Labor, Department of Education, Department of Health and Human Services, and to make sure that these agencies can be trusted. The department and assistant department heads would be facing either loss of their employment or jail time if their agency did not obey the finer points of this bill, should it become law. And that's what the federal government did in Sarbanes-Oxley. That's the reason they're being very careful. The CEO and the CFO will go to jail if their numbers do not jive, excluding a mathematical error. And thus not just have the majority of enforcement dumped into the laps of the law enforcement community that pretty much have all sustained budget cuts and thus manpower shortages. Or you could have a one-stop shop agency that checks with the SAVE program to get reliable immigration status on all immigrants to verify if a person is eligible for government social services assistance. Lastly, this enforcement is going to require a cost. So in the stopping the social services support and payouts to these illegal aliens to the tune of approximately $2.4 billion annually, which is sure to rise if for no other reason but quantitative easing too by the Federal Reserve. this enforcement is going to require the state to spend some money. One must spend money to make money, and the money made will be the state funds that are not paid out for illegal aliens and to the Georgia families that are unemployed and receiving state-funded social services, because with illegal aliens not being able to get work in the state, the employers in Georgia will be hiring Georgia citizens to fill these vacated positions. Then the Georgia citizens won't be on unemployment and state-run subsistence programs. Any questions?
Dr. Hudson, thank you for your testimony this morning. I see no questions.
Okay.
Thank you for taking the time and also for being patient with our process. Along those lines, I made a commitment the last hearing that if people wanted to be heard, they would be heard. One of the curses of this process is the process, and that is that it's sometimes time-consuming. And pursuant to that commitment, we will go ahead and have a final hearing on Friday morning at 9:30. It'll go from 9:30 to noon, just like today, and we are at 12:03 p.m. right now. So miraculously, we've been able to keep on schedule. That'll probably never happen again, but I want to thank everyone for their feedback, for their input, and for their measured presentations this morning. I think it's been beneficial regardless of what side of the issue folks may be on. We'll be here at 9:30 Friday morning. We will go ahead and limit time as we have today. These are for individuals as opposed to organizations to speak. We'll probably limit that time to 5 minutes. If we end up being more economical with time than we thought, we'll try to expand that. We're just trying to do the best we can and while keeping the wheels on the process turning. If there are any written materials that people want to go ahead and supplement either their testimony from this morning or in preparation for any testimony this coming Friday, that is certainly fine. We welcome that. We would rather have more information rather than less, and we'll march on from there. Just want to make sure that's clear. And we're adjourned. Thank you.